Obviously a historic day for the ECCC, hopefully for many Cambodians as well, because this is the first time that the court has reached a final judgment in, deciding criminal responsibility for some of the members of the national leadership of the Khmer Rouge. So just to summarize very briefly what was the findings of the Supreme Court chamber, because I noticed that there were some confusion among the media about what was actually decided in addition to the sentencing. The Supreme Court chamber first, they upheld the sentence of life imprisonment for Khieu Samphan and Nuon Chea. They upheld the convictions against Khieu Samphan and Nuon Chea with regards to the evacuation of Phnom Penh, with the exception of the crimes against humanity of extermination. And for the second population movement, which started in 1975 and went into 1977, the Supreme Court chamber upheld the conviction for crimes against humanity of other inhumane acts. They overturned the conviction on crimes against humanity of extermination. They overturned the conviction for crimes against humanity of prosecution on political grounds, and they entered a new conviction for the crimes against humanity of murder. When it comes to the convictions against Khieu Samphan and Nuon Chea for the crimes committed at Tulpu Shrey, the Supreme Court chamber reversed the conviction in its entirety. It's important to emphasize that the Supreme Court chamber did rule that there was evidence of a massacre at Tulpu Shrey, but as was said in the summary and which is further described in the judgment, they have not been able to establish beyond reasonable doubt the individual criminal responsibility of Nuon Chea and Khieu Samphan related to the killings at Tulpu Shrey. So these were briefly the findings of the Supreme Court chamber in its appeal judgment.
Thank you, Mr. Lansoson, for summarizing the judgment for the national and international press representative, so that they understand about the sentencing decided by the Supreme Court chamber. And allow me to greet Madam Chia Liang, who is the National Co-Prosecutor of the ECCC, as well as Mr. Nicholas Komjun, who is the International Co-Prosecutor of the ECCC. And our press conference starts with the co-prosecutors. And the co-prosecutors, actually each party has 20 minutes for the press conference, and in the interest of time, I'd like to hand the floor to either national or international co-prosecutors to make a brief statement for 1 to 2 minutes, and then leave the floor for question and answer session by the national and international press representatives. I'd like to hand the floor to you. Chia Liang, thank you. And allow me to welcome both national and international press representatives. I also would like to welcome Cambodian people and the victims of the Democratic Cambodia regime. We have been waiting for over 37 years, and today is the day. Today we received the light of the justice. And our charges against the accused, and there were 5 initially, and 2 passed away. As for the 3 remaining survivors, we are successful in prosecuting them. So there is a success, a historical success for victims, either living here or abroad, because some victims have moved to live abroad. So today's justice is acceptable to those people, and that will contribute to some extent to their relief. And I'd like to actually have questions from you, so that I may answer your questions, and all your questions are welcomed. And of course, whatever I can answer, I will answer your questions. And I will also give the floor to my international colleague, whom I have been working with, to make a brief statement, and then we leave the floor also to you to put questions to you, since 20-minute time limit is not that long. Thank you. Thank you, Madam Chia-Ling, for your brief statement in relation to your position and reactions to the final judgment. And now I'd like to hand the floor to Nicholas Komchun to make a 1 or 2 minute statement.
Thank you. I just want to thank all those who testified during this trial, because without them it would not have been possible, and all those victims who testified, civil parties who participated in the proceedings. They are absolutely essential for what happened. I know for many of them it was difficult to relive extremely painful periods of their lives, but their contribution is essential to reach what we've reached today. And what I hope is that this judgment and the judgment in case 2-2, which includes many more charges and many of the more serious charges of what happened during the DK regime, will provide these victims some measure of peace, some knowledge that the world has acknowledged the suffering that they went through, and that persons are responsible, criminally responsible for that. So, and I'd also like to thank the whole team at the OCP that worked on this very long trial, a lot of it for some years before I even arrived, and also during the appeal. We really appreciate all the work they put into it. And sorry, one other thank the donors of the court, because without the donors, without the financing, this court would not exist. So I think it is important to acknowledge also those that have contributed financially to set up this court through this long and very complex process in what I think is clearly the most important trial, at least since Nuremberg, involving the most horrendous crimes since the Second World War.
Thank you, Mr. Nicholas Komchun. Now it is a question-answer session, and you may put questions to the co-prosecutors. Please state your name and the press that you are representing.
We do not hear you. Say again.
Microphone is not on.
No, please. Oh. No.
Hello?
Yes.
Okay.
So the court's been dogged with accusations of political interference. Nick, do you think this is fair, and what do you make of these allegations?
Well, today,
Question by question, or we collect question first?
it's up to you.
One by one, or two or three more questions?
Check how many questions are
Okay.
OK, ឥឡូវបាទសូមអញ្ជើញ
And let me have a few more questions, and then we will answer those questions as a group.
Erin Hanley from the Cambodia Daily. From the Phnom Penh Post. And I guess I just wanted to ask the prosecution what you thought of the reversals today. Were you disappointed, especially in relation to the Tol Potre crime site, and whether you have any thoughts on what impact that will have on victims? I also want to know about the joint criminal enterprise, the most extended and third form of that was also not considered for this case. Do you have any concerns about how that will affect the ongoing case 2-2 and later cases here at the court?
One more question. If not, then let the co-prosecutors answer the two questions first. So I'd like to hand the floor to the co-prosecutors.
Okay. Well, first of all, and I think this answers in part both questions, there were aspects of the judgment today that I was disappointed in. We made our arguments, but also we understand that we're prosecutors and they're the judges, and the judges ultimately decide. And similar to an election, sometimes you may not like the result, but if you believe in the rule of law, then you accept that institutions are independent and they may reach results that the parties, any one of the parties, is not particularly 100% pleased with. I think in the deliberations, the short summary that we read, what's clear is that the judges deliberated in great detail about the findings of fact and the applicable law to this case. Of course, I want to read the whole judgment, but the impression I have today is the institution has something it can be proud of to show that it's a very serious institution where all parties were given extensive opportunities to make their case. Very extensive evidence was admitted, and the process reached this result, which, while I may not agree with all of the details, I think the ultimate result in a life sentence in this case is justice. As far as the joint criminal enterprise, again, while the chamber said they did not consider our appeal admissible because we had said it did not affect the judgment, it sounded like from the summary that they considered the issue and disagreed with us, finding that the pretrial chamber was correct in holding that JC3 was not part of customary international law in 1975, which is different from what other international tribunals have held. However, also in listening to the judgment, the chamber seemed to make some important holdings regarding the intent for what they call the first form of joint criminal enterprise. And I have to read the whole judgment, but I don't think the overall findings will hinder us in any way. We were not asking for that to be applied to case 2-1. We don't think it's necessary in case 2-2. We think that all of the crimes that were charged would be part of the criminal plan that was agreed upon. As for other cases, it's a bit speculative. I really don't want to go into it, especially since I haven't read the whole judgment.
I'd like to hand the floor now to Madame Chilian. Allow me to respond to the questions by Cambodia Daily and Phnom Penh Post regarding the political interference by the Cambodia Daily journalist As for Phnom Penh posed question, that is for the facts that happened at Tulpu Tray and JCE 3. The Supreme Court chamber read a summary of the full judgment, and of course this is only a summary and it is not a full judgment. And that the question you raised is what was appealed to the Supreme Court chamber by the defense. And I hope you had listened to the summary of the judgment, but allow me to express our position regarding our independence. We relied on the existing law, both national and international co-prosecutors worked within the framework of the existing law, in the principle of law as well as in the agreements between the regular government of Cambodia and the United Nations. It stipulates the duties undertaken by the co-prosecutors and which groups of people that we could charge. If you refer to these laws and agreements, either in a form of book or on the website, you should know that there are only two types of people that the OCP can charge. First, those who were the senior leaders and those who were most responsible. We cannot step beyond this boundary, and if we were to, it would be rejected or dismissed by the co-investigating judges. So before we begin our prosecution, we have to refer to our limited scope. As for our independence, we also have to refer to the relevant law. If the law is so expressly stated, then we have to abide by the law. And allow me to remind you, this is a hybrid tribunal, and Cambodia itself is a civil law judiciary. And the prosecution is entirely based on the existing law, which was adopted by the National Assembly, and it went through the Senate, and then the Constitutional Council. We, the co-prosecutors, had to apply the existing laws, and that is what we do in the civil law system. We cannot say that it's because of the political interference that we fail to judge this person or that person. That is not the point. Second, in relation to our disappointment, if any, that our charge against the accused for what happened at Tulpu Tray, which was dismissed or reversed by the Supreme Court chamber. I have not read the full judgment yet because the summary is indeed very brief, and we will try to read the full judgment first so that we can understand the reasonings behind the rejections by the Supreme Court chamber and whether it is acceptable. If they rely on the existing law, of course, we won't be disappointed because we want justice for everyone, namely justice for the victims and justice for the accused. That's what we want. We not only want justice for one side, but we want justice for both sides. So let's wait to read the full judgment, because today it's only the delivery of a summary of the judgment. And the third point is in relation to JCE 3. The questions that put to my understanding is that whether this judgment in terms of JCE 3 have any impact on the ongoing trial in case 002/02. In the view of the OCP, it's not going to have any impact on the ongoing trial because the facts within the latter segment, we have evidence beyond a reasonable doubt And for that reason, we will show all this evidence to the trial chamber so that they can rely on it and use it as a basis for their decision. And again, this is our view based on the applicable law. And I believe it is sufficient for case 002/02, which is going to conclude very soon. And when I refer to 02/02, it means the second phase or second segment of case 002. For the co-prosecutors, there's still 4 more minutes remaining. Any further question?
3 minutes more with the co-prosecutor មាន3នាទីដើម្បីសួរទៅកាន់
So now there is still remaining 3 more minutes if you have questions. For the national press representatives or journalists, you have any question? If you don't have any question, I'd like to ask whether Mr. Nicholas Kumchun or Madam Chiling have anything else to add before we conclude our session.
Yes, I just want to remind, some people may have the question out there, okay, you have a life sentence affirmed. Why does case 22 matter? In my view, it still matters very, very much. The great majority of the victims of the Khmer Rouge regime were victims of crimes that are part of case 22. This includes all of the internal purges by the regime. It includes all the killings of Lon Nol officers other than at Tulpotre and many other places. It includes the forced marriage of many, many tens of thousands of couples around the country and the rape within those forced marriages. And it includes charges of genocide against 2 separate groups. So it's very important in my view that those crimes be adjudicated and be acknowledged, and that those victims see a formal process acknowledging what happened to them and the criminality of that. That a government doesn't have a right to simply kill, control the lives of its citizens in every way, and kill anyone it views as a threat.
លោកជំទាវនៅសល់ពេល1នាទី
And Madam Chiling, you have 1 minute. Thank you. And I will actually use that 1 minute. I know that the time is limited. Again, allow me to state our position and our duties for both national and international co-prosecutors. We are the initiators of this criminal complaint, and as a result, we received a final judgment by the Supreme Court chamber in case 02/01, as well as our previous judgment in case 001 against Kangaj Elias Luch. We have endeavored to bring justice to the victims, and today's result will be favorably accepted by the victims who have been waiting for over 30 years. This is a final judgment, and it is not open to any further appeal, and that the two accused are convicted for life imprisonment. This is a historic day for this mixed tribunal, because we have achieved a great success, and that thanks to the contribution by national and international staff, as well as the financial support by the donor countries. During the Democratic Cambodia regime, we did not have any applicable law to use, we did not have any court, but now Cambodia is a state of law, and we try to eradicate impunity so that it is shown that Cambodia is progressing in that path, and that the world itself should also follow the same path. and this is a very positive way forward. And again, I do hope that the victims would accept today's judgment, and in some way the judgment would contribute to their relief. Thank you. Thank you, Madam Chia Liang and Mr. Nicholas Komchuan for attending this press conference after the delivery of the final judgment. We now move on to the second group, and allow me to thank Mr. Komjian and Madam Chia Liang. And also I'd like to thank the working groups of the co-prosecutors. We now move to the defense teams for Nuon Chea and Khieu Samphan. And since this press conference is live by Yon TV, I'd like last to again make a summary on the sentencing of Nuon Chea and Khieu Samphan by the Supreme Court chamber while we are waiting for the arrival of the next party.
Okay, so to repeat the summary of the holdings of the Supreme Court chamber this morning, it was that the Supreme Court chamber upheld the life imprisonment sentence imposed by the trial chamber, but they did change, they made changes in the convictions of Nuon Chea and Khieu Samphan. Most notably, they reversed the convictions related to Thu Push Ray, where the Supreme Court chamber found that although there was a massacre in Thu Push Ray, there was insufficient evidence beyond reasonable doubt to establish criminal responsibility for Khieu Samphan and Nuon Chea. They also overturned the conviction of crimes against humanity of extermination in relation to the forced evacuation of Phnom Penh and the second evacuation phase, and they overturned the conviction for persecution on political grounds for the second evacuation from 1975 to 77, and they entered an additional conviction of crimes against murder.
I thank you very much, Lars Olsen, the officer in the public affairs section, and now we can see the arrival of Aung Dae Gwise, the international co-counsel for Mr. Khieu Samphan. We are awaiting other colleagues who are joining the defense teams. And here we have Victor Cooper. He is the co-counsel for the accused Nuon Chea. And we also have the presence of Kong Sam On, the national co-counsel for Mr. Khieu Samphan. Now we can. Now we have the presence of the two defense teams for the co-accused Nuon Chea and Khieu Samphan, and we now start the press conference of the defense team for Nuon Chea and Khieu Samphan. And again, good afternoon, Aung Dae Gwise. She is the international co-counsel for Mr. Khieu Samphan. And good afternoon, Kong Sam On. Mr. Kong Sam On. Mr. Kong Sam On is the national co-counsel for Mr. Khieu Samphan. And here we have also the presence of Victor Cooper. Good afternoon, Cooper. The defense team for co-counsel for Mr. Nuon Chea. The defense team so will have 20 minutes for their session. And the co-prosecutor team used 21 minutes. So 1 minute is added to the defense team for the two accused. And we would like to give the floor to the defense team to introduce or to, say a few words before we open the question and answers. Kong Samon. Thank you very much. Good afternoon, everyone, ladies and gentlemen. As of now, we have not yet received the full written judgment as made mention by the co-prosecutor, so we cannot give any detailed comments on the written judgment. What we really want at this time is the reasoning based on law by the Supreme Court chamber. Then we will study the written judgment very soon. And Antaguise, you can now have the floor.
Thank you. Good afternoon, everyone. I'll begin by saying we looked at the corridors of this tribunal today, and we saw how serious it was in recent days. The doors were repainted. We made this tribunal beautiful so that people could come in their lovely suits in order to attend this announcement. So that we could look at the appellate judgment, and we would like to say that we have seen this cosmetic justice. And I would like to explain myself when we say cosmetic justice. We heard today several of what grounds that Nguyen Chia and Khieu Samphan had put forward. And we heard that some of the grounds were recognized, and we saw that there were errors that were made by the trial chamber. However, we've also heard that that doesn't really make a difference, and that the final thing is that there is a guilty verdict against Khieu Samphan and Nguyen Chia. So I want to say that these are simply words of, people will say they are simply words of a bitter defense, but actually no, we are lawyers, and issues of law are essential. So as my colleague Kom Samon said, we have to wait to read the full written judgment in order to see the full reasoning of the Supreme Court judges. All I can say initially is that yes, the Supreme Court chamber has done away with Joint Criminal Enterprise 3, which is the broadest one. But from what I've understood today is that the JCE 1 does pose a criminal problem. But this appeal judgment has come 2 years after our appeal, and the only feeling we have today is to say that, well, finally, it took 2 years to try to incentivize and reject the most essential points of our legal arguments, and that's already a sign of something. As I have said, and we've said it several times already, this is a symbolic decision. And once again, I'm talking as a lawyer. It's always very frustrating to see that a symbol erases rights and laws. And we feel this on behalf of Khieu Samphan. Clearly, it's only partial, but from what we've seen, certain arguments were rejected, even though some were upheld. But that's my first reaction, and if you have any questions, please go ahead.
Before we open the floor for question and answer session, and now I would like to invite Victor Copper to say a few words. I have to respect the time for all parties. That is the fair process for everyone in the case.
Yes, I'll be brief. To be honest, I was pleasantly surprised by many considerations given by the Supreme Court chamber. Then again, that was not too difficult because, of course, beforehand we had zero expectations in respect of what that judgment would be. Nevertheless, I just spoke to Nguyen Chia in the detention center, explaining to him briefly what the judgment was about, because of course there were many legal points discussed which were not immediately clear to him from the start. I told him that there were many interesting and good points in that decision. I told him that I was quite delighted with the acquittal in respect of Tu Po Tray, even more so in respect of the acquittal of the extermination charges during the evacuation. Even more happy I am with the raising of the standard of the evaluation of evidence. One of our main complaints in case 2.1 and especially in case 2.2 is that the standard of accepting proof on certain events is so incredibly low. That bar has been raised now extensively, which I believe could have a substantial impact on running case 2.2, most particularly the genocide charges, because the evidence there is very sketchy and anecdotal. I think the prosecution is not going to be very happy with that. So, to sum up, some very good points, some very interesting considerations. Of course, what I couldn't explain to Nguyen Chia is, with acquittal on crucial points, why it was a life sentence again. That is something maybe you have a suggestion, but that's something that I cannot explain to him. Not that it matters materially, because he's 90 years old and he will have only short time left. So materially it's of no concern, but if you grant so many points in the appeal, then why is it still a life sentence? I suppose that was presumably the compromise that Cambodian judges were willing to concede to. I think the international judges were quite keen on acquittal of certain points, and in return they must have said, well, you can convict him to a life sentence again. That's what I think went on behind the scenes. One last point, if I may, that is, of course, the decision, on the one hand, to criticize not calling Heng Samrin as a witness, but then not summoning himself, not summoning Heng Samrin to appear before the Supreme Court chamber. That is something that I really cannot follow also. They say, trial chamber, you're wrong in reasoning and in making that decision, but at the same time, the Supreme Court chamber hasn't called Heng Samrin, and that is of course problematic because it reminds me of a dissenting opinion of the Belgian judge at the ICC 2 years ago, who said that if you realize that crucial evidence might be missing from the record, then the only solution would be acquittal on all the charges. And I'm meaning then especially the charges of murder during the evacuation, because who was responsible for the implementation of the decision to evacuate Heng Samrin? So whether there was really intent to murder people during the evacuation, the person to give evidence on was of course Heng Samrin. So that is something that I really cannot follow. You say that Heng Samrin is an important witness, you don't call him, but then you do convict for murder during the evacuation. Having said that, I think the prosecution is in big trouble in case 2.2. I think they realize that. So in that sense, I'm positive and optimistic.
Thank you, Copper. And now it is time for question and answers. And please introduce yourself and put the question up.
Hello.
Daily.
I am Sombo.
Irrelevant.
George, can you hold on, because there was one guy who gave we gave the floor to one before you.
Okay.
Yeah, please.
Some change, Sambo.
Now, Sombo, it is your time. I would like to ask the defense teams for the two accused. What do you really want the judges, Supreme Court judges, to review before this judgment? You are asking the defense lawyer or judges? You want to ask what action should the defense team take after the delivery of the judgment? I would like to ask the defense team to inform all of us which points of fact and laws you require the Supreme Court chamber to review. Thank you very much, Sambo. And second question, please.
Appeal irrelevant beforehand. Do you still stand by that? The appeal judgment, that is.
As you have observed, I've become a bit milder in my tone. The thing is, what impact will it have on the judges in the trial chamber? I have said on many occasions that they are deeply biased and incompetent. Will they take to heart what the Supreme Court chamber has said? That would mean such a change, a complete change of everything. That would be impossible. In that sense, the judgment is irrelevant. Also, and that's very unfortunate, the judgment comes at the very end of 2-2. So it is unlikely that the trial will go on for another half year. I sincerely doubt that. So, although there are some very interesting and positive points from the judgment, at the end of the day, it will be irrelevant. Because what is the signal, for instance, in respect of Heng Samrin? Heng Samrin is even more crucial, much more crucial in 2-2. The Supreme Court chamber says it's okay not to call him. He is our only character witness. He is an incredibly important witness, and the Supreme Court chamber has said, well, you know, it's not very nice, but it's fine. So in that sense, I stick to the characterization of being substantially irrelevant, yes.
And Kong Samon, you can now answer. Kong Samon, I would like to answer the question. And it is perhaps my observation that I want to make in relation to the appeal judgment. The Supreme Court chamber found that Kyew Sompon was not engaged in the ordering, but he supported the policy to engage in the revolution in the democratic Cambodia. So there are a lot of suspicion. There's a lot of points, confusing points here. Participating in the revolution is not criminal to me. Attending the meetings and making the statement or speeches are the relevant points considered by the Supreme Court chamber. And the Supreme Court chamber found that Khieu Samphan did not participate in any meetings in 1974. So if Khieu Samphan did not attend those meetings, so why was he found guilty of participation in the policy? And in relation to the meetings in the center and the standing committee, some documents reflects the name of Khieu Samphan and the presence of Mr. Khieu Samphan. But in those meetings, Khieu Samphan could not prevent the decision made by the meetings. So simply present in the meetings is criminal. Is it fair for Mr. Khieu Samphan? That is the question for you. And if we talk about speeches made by Khieu Samphan, so where is the evidence showing that Khieu Samphan supporting the evacuation phases 1 and 2? His speeches concerned only the situation in general nature. Crimes in Tulpurchre were reversed. So Khieu Samphan should be found not guilty in relation to evacuation phases 1 and 2 at Tulpurchre.
Just perhaps one last point, which represents a great frustration for the defense. It is effectively concerning the mode of liability, because the simple political participation was basically insufficient to convict. But we will be reading the in-depth conclusions and reasoning of the Supreme Court chamber. So we'll be looking at what the dolo eventualis and the difference between that and the direct participation, how they managed to reconcile that with the mode of liability, which is nevertheless involved in the commission of a crime. So it's legally of extreme importance. Although it's secondary, given it's symbolic, but it's still very important. And since we're talking about the legacy of the ECCC, I think that if we have a decision on a point of law which does not respect the principles declared by the ICCC and concerning the retroactivity of laws and the principle of acting in the function of international criminal law or international customary law, which was set at the time, I think we have the impression in what we heard today that there is a real problem in what the judicial legacy of the ECCC will be.
And 2 minutes left for the defense teams. And you can say the final words, or you open the floor for further questions and answers. Now, we would like to receive the question instead of making the last words. I'm Smay from Phnom Penh Post. When you, counsel, met Nguyen Chia, you, Kong Samon, said that you met Nguyen Chia after the close of the hearings. What did he say? And did he want to say anything to the Cambodian people in general? And Dino, you have question? Please, short question. 1 minute left. I am Hulino from PNN TV station. Earlier, a bit earlier, when the defense team for Mr. Kyu Sampon grabbed the microphone, you said that you felt disappointed. So are you satisfied with the Supreme Court appeal judgment? And what do you want? You want the courts to acquit Nuon Chea and Kyu Sampon? Now you have only 30 seconds. You can give your answer.
I'm afraid I can't say what the reaction was of Nuon Chea. I've told you what I have tried to explain to him. What his reaction was, that is between him and me. What I do want to stress is that Nuon Chea has said on many occasions that he is very willing to answer questions, to speak about what happened, but that he's refusing because of the way these proceedings are going. And recently he said, in the case that Heng Samrin will be called as a witness, I might change my mind and answer questions. So there is still this possibility that he is going to speak also about events discussed in the Supreme Court Chamber decision. But it's all up to the trial chamber to call upon Heng Samrin.
Kong Samon and Ang Tan Guse, please give your short answers. Kong Samon, I thank you very much for my last words today. I can say that in general, the appeal judgment against Kyu Sampon is focusing on one specific intent, which is not really criminal in nature. And there is no evidence showing that Kyu Sampon is engaged in those acts, criminal acts.
I'll answer your question very briefly. Yes, we are disappointed because we believe that in terms of law, Kyu Sampon should have been recognized. But unfortunately, the law kind of erased itself before the symbol.
Thank you, Ang Taguse, Kong Samon, and Victor Coupe for your time in the press conference. And the defense teams used 23 minutes, and now we will proceed to the lead co-lawyers for civil parties. And while we are awaiting the lead co-lawyers for civil party, I do not know whether Lars want to add something more.
Okay. Since we are still live on Bayonne, we would like to repeat again for people who have recently tuned in to this press conference that this morning the Supreme Court Chamber of the ECCC upheld the life imprisonment sentence for Kyu Sampon and Nuon Chea. They upheld some of the convictions in relation to the evacuation of Phnom Penh and in relation to the second wave of evacuations, whereas the Supreme Court Chamber reversed the conviction of Nuon Chea and Kyu Sampon with regards to the massacre at Tulpur Srey. The Chamber did establish that there was in fact a massacre in Tulpur Srey in April 1975, but the Supreme Court Chamber concluded that there was not sufficient evidence to establish beyond a reasonable doubt that Kyu Sampon and Nuon Chea could be held personally criminally responsible for what happened at Tulpur Srey.
សូមអញ្ជើញខាងក្រុមតំណាងមេធាវីដើមបណ្ដឹងរដ្ឋបវេនី
Now I would like to invite the lead co-lawyer for civil parties to come to the stage for the press conference. I would like to inform the public that the ECC is unique in nature, and it recognizes the victims to act as civil parties in the proceedings, and civil parties recognized under this case is 3,600, and they testify before the chamber. They can testify of the facts and also the sufferings of the crime. And now we have Marie Giraud, who is the lead co-lawyer for civil parties, is a French lawyer. And let us welcome Mr. Pic Ang, who is the co-lawyer for civil parties on the national side. And good afternoon, Marie Giraud and Pic Ang, who are lead co-lawyers for civil party, and you are now attending this press conference. I would like to inform two of you that you have 22 minutes to respond to the question and also to make a statement. And now I would like to give the floor to Mr. Pic Ang, who is the lead co-lawyer for civil parties, to make a statement. Good afternoon. I heard that the defense counsel had 23 minutes, but I have only 22 minutes. So in principle, we welcome the outcome of the pronouncement of the judgment by the Supreme Court chamber. This is the evidence that show us that this is the elimination of impunity for serious crimes, and there must be prosecution and tried for those crimes committed not even in Cambodia but in other countries in the world. And this pronouncement of judgment is one of the success that civil parties participated in proceeding, and the judgment and reasonings are acceptable, and the court gave us opportunity to request for civil reparation for the victims, and this is very good for the victims, even though they are seeking for a better or broader trial, but it is impossible for us to do so. But we have to respect the scope and the applicability of the law. Thank you, Mr. Pic Ang, and Marie Giraud. You can make a statement or remark at the beginning, and we can wait for the question after that.
Thank you, and good afternoon to all of you. First of all, we have just left the debriefing with about 100 civil parties. And I can say that the general feeling was a feeling of satisfaction. Satisfaction because the sentence, the life sentence for Khieu Samphan Noonchea has been confirmed. Satisfaction as well because this long legal process is coming to completion. Whereas more than 100 civil parties have died since the beginning of case 002. And also I would like to say that since I read the judgment briefly that was notified to us about an hour ago, it appears to us that this this judgment is of a high legal level, that this judgment addresses the issues of equity and impartiality, without any dissenting opinion apparently, which is important to note. Because this means that the international and Cambodian judges together recalled a certain number of principles in terms of equity and impartiality, and have validated the proceedings here before the ECCC. This is a victory, personally speaking, for the civil parties as well, because the SCC confirmed the Chamber's approach, which used the evidence on a broad scale, the oral and written evidence that we presented during the entire trial, and also we're satisfied, finally speaking, because of a definite sentence is also a form of reparation for the civil parties. And with this decision, which is now definite, this is the first time in the history of international criminal justice that reparations have been recognized by a legal authority and implemented in full on the field. And in this regard, we circulated a little press release which provides you with a few elements regarding these reparations. In particular, you have a table that recapitulates the reparations that, thanks to the definite sentence of Khieu Samphan Nunchia, will become true legal reparations now. And I might answer questions in that regard, if you have any. And we also provided a second document to you which allows you to look at to have the most updated status of the reparations that we're requesting in the current case, which is coming to a completion before the trial chamber. That is to say, case 002/02. And in order to provide you with some concrete elements with regard to the reparations, which now have become judicial reparations because of the definite sentence of Nguyen Chia and Khieu Samphan, the trial chamber recognized that it would be necessary to organize a national day of commemoration, and nothing can prevent a decree to come into effect in that regard, so that this day of remembrance be honored in Cambodia as of 2017. I will stop here.
Ms. Van Rom, thank you for your remark, and now it's the time for question and answer. I'm from Town Radio, and I would like to ask question to the lead co-lawyers for civil parties. Do you receive, you feel satisfied or acceptable after the announcement of the verdict, especially regarding the remembrance and memorialization, and when we are talking about the trial of the senior leader of the DK who are very elderly, so are these acceptable to the victims of the regime? My name is Hondino. I am from PNN TV station, and good afternoon, everybody. I've heard from the Defense Counsel for Nuon Chea and Khieu Samphan, who addressed that the judgment by the Supreme Chamber is not justice, fully justice to them. And what is your, in your opinion, for the lead co-lawyer for civil parties? Now we allow another question, the third question.
What was their reaction? Do you want me to repeat that? Of course. I wanted to know if you had any civil parties who were directly affected by the crimes committed at Tol Po Tre, and if so, what was their response given the reversal of the convictions at that crime site?
Swanram. Now the floor is given to both lead co-lawyer for civil party to respond to the questions. Big Ang. I would like to respond to question number 1. When you are talking about the degree of satisfaction of the trial hearing, especially the life imprisonment, and as you heard, the judgment of the trial chamber has been confirmed by the Supreme Court chamber. In general, we are happy and we support the judgment by the Supreme Court chamber. And regarding the sentencings, and this is one of the most serious guilty or penalty under Cambodian law, but we are not very satisfied with one point in the judgment, that regarding the presentation of evidence in the court, that Mary Kiro will mention in point number 3 or question number 3, and regarding the hearing or the trial proceeding in which participated by civil parties and what are their reactions. And I have talked to the civil parties, and they are also happy with the Supreme Court chamber judgment. And as for the remarks by the defense counsel that the judgment by the Supreme Court chamber is not acceptable to them and not really just for them, and it is quite normal for the defense team of the accused. But the most important here is that we need to look at the evidence established before the trial chamber and also before the Supreme Court chamber, that most of those evidence are incriminating. And we are also lawyers, and we believe that they are the person responsible for those crimes, because we base on the evidence, testimony of witnesses and civil parties, and also legal argument to be based upon before the conviction. So it is not a good idea for them to say that it is a symbolic justice. So I leave one question for Marigiro to respond the remaining questions.
Thank you. I heard the Kyusompon defense saying that law had disappeared before the symbol. And I believe, on the contrary, the Supreme Court has really practiced law in its decision today. Especially regarding Tupu Shrey, corrects the interpreter. We had 20 civil parties that were admitted by the co-investigating judges because they lost loved ones at Tulpul Shrey. If these civil parties were admitted because of this harm, this means that they were all victims of other crimes, crimes covered in case 00201 as well as in case 02/02. And what we explained to the civil parties before attending this press conference today is that the Supreme Court chamber recognized the existence of crimes against humanity at Tulpul Shrey. Crimes of murder, extermination were committed at Tulpul Shrey. And however, what the chamber said was that it could not retain Kyusompon Anuncia's criminal responsibility in that regard. It noted, however, that the severance in the fact of limiting in time the evidence that could be used in order to assess Kyusompon and Nuncia's responsibility with regard to Tulpul Shrey had or might have had an effect on this decision. So what we're explaining to the civil parties is that this appeal judgment of the Supreme Court chamber offers them many, many reasons to be satisfied. And it's always in the interest of the victims that the rights of the defense are respected. And this is part of the right to truth, such as was recognized by international criminal justice. That is to say, the right to truth, yes, but not to any kind of truth. And we have the impression today that justice has been done.
Damswanaram. Thank you, Marie Guru and Pek Ong. Now that you have 3 minutes and 30 seconds, if you have any other question, you may ask to both of them. If you don't have any question, and I would like to give the floor to Marie Giro and Pek Ong to make a closing remark if you have any remark to make. Pek Ong, I would like to say that the judgment by the Supreme Court chamber and the prosecution of the crime is a very important symbolic effort for Cambodia and also other country, because especially when we look at the criminal responsibility for the first transfer of people from Phnom Penh, and also the second transfer of the population, and also the crimes at Tuolpo Chri, and also other crimes happen in other places. These are the important points of the case, and I appreciate, and also my colleagues also appreciate the efforts of the civil parties and witnesses who made their time to testify before the court. More importantly, the civil parties who testify before the chamber. What they need from their effort was to find the truth, and they were very brave to participate in the proceedings in order to seek for justice. Even though they are now living in poverty, they are in poor health, so justice is very important for them. Damswanaram, thank you, Pek Ong and Marie Kiro. You have 1 minute to make a remark if you wish to do so.
Well, then I wanted to pay homage to the civil parties. Who joined us in this legal adventure about 10 years ago already today, without necessarily knowing how long the process would be and how many obstacles there would be along the way. So indeed, I have kind thoughts for them, because this is indeed an achievement. So these are my last words, a thought for these men and women, the civil parties.
Damswanaram, thank you very much, Marie Giro and Pek Ong, who are lead co-lawyer for civil parties. And thank you also, Mr. Lars Olsen, and on behalf of the moderator, the chief of PAS at ECC, and thank you, colleagues and staff, and also thank you, national, international press representatives who attend the session since the beginning, and also you cover every parties, including the co-prosecutor, the defense counsel, and also the civil party in the process. And thank you also Bayon TV, who can cover live coverage from the court. And thank you, Mr. Minister Kieu Kanyurat, Minister of Information, who authorized the cooperation to cover from Bayon TV for other TV stations in the country. And thank you all TV stations who covered the pronouncement of the judgment by the Supreme Court chamber, and also special thanks given to the general public. And I would like to close now.